Good afternoon, and we want to welcome you to the Court of Appeals. Madam Clerk, are there any preliminary matters this afternoon?
No, Your Honors.
Would you please call the first case then?
John Jahen versus AER Express, Inc., et al.
And before we start, sir, do you want to reserve any time for rebuttal?
Yes, Your Honor, I would reserve 3 minutes.
Thank you. Okay, if we're ready, then we can proceed for the appellant.
Your Honor, Buddy Presley from the Chattanooga Bar.
Yes, sir.
On behalf of AER Express. Your Honor, I've been in this court a few times, probably too many times to remember. And with cases that I have, I've kind of started with describing them, each one of them individually with a moniker. In this case it's just not right. This case started in 2012, and here we are today, 2023. It was originally filed in 2012. Summary judgment was denied in 2012. It's all part of the technical record, Your Honor. And kind of what's important in this case is during the course of this litigation, nothing really happened from 2012 to 2018. It just sat. Prior counsel in this case, because I came in after all the explosion, just as such, and I came in but prior counsel, there had been 2 prior counsels that had been allowed to withdraw out of the case in 2018. The high marks are that a witness and exhibit list that's in the record was filed in March of 2020. And then the other important item in the record is the final order granting a judgment in 2020. I filed my motion to set this aside, that judgment aside, in July 2021. This case centers on the Chancellor's denial of that motion to set aside the original judgment granted in November 2021. And my argument is fairly simple and straightforward, and that my client didn't have notice. AER Express, in this particular instance, did not receive notice that there was going to be a hearing, a trial, did not receive notice of witness and exhibits list, did not receive notices of the final trial in this, which had been put off a couple of times, did not receive any notices of that. You know, and that's been my crux of my argument throughout this case, is that there was lack of notice, and therefore, in this particular instance, because of that lack of notice, this judgment was granted as effectively a default judgment. No one was there to defend, and no one was there to prosecute any sort of defense, and so it amounts to a default. And Tennessee law has been fairly consistent and strong with regards to default judgments, and that there are drastic sanctions. In this case, the judgment was well in excess of $200,000. And I've consistently argued that throughout this process in my appellate brief and in my motion to ultimately try to set aside the original judgment. The court has looked at factors in trying to determine whether or not a judgment should be set aside, and we're riding under 6002(1), and those include whether the default was willful, whether the defendant had a meritorious defense, and whether the non-defaulting party would be prejudiced. our arguments are that obviously there was no willfulness because our client didn't know. They didn't have notice. They had no idea that this was going on. When they found out, I immediately filed the motion. Whether they had a meritorious defense, that's in the record, in some of the pleadings, and in our in the argument with the court. This was essentially originally a workers' comp case, and the defense was they were not an employee, and that defense was never allowed to be pursued or proven right or wrong because the judgment was granted without my client being there.
We have to look at what reason your client did not have notice of the hearing.
Well, Your Honor, the reason is they never got anything from the court. They never got anything from the plaintiff.
But why did they not get that?
Well, one of the arguments that we've consistently made in this is that once their counsel withdrew, the plaintiff started using an address that was erroneous. In that address, my client had not been there for more than 2 years. I think the record reflects from my argument in the hearing that it was as simple as just looking it up on the Secretary of State's website and you'd find the address. But there's also the fact that in the technical record, there's nothing which shows that my client got anything. There's no, the defendant, the plaintiff in this case, list.
The clients sort of have an obligation to keep up with the court to make sure that they're in contact with the court while their case is pending.
I believe that I don't think clerks have an obligation. I think parties do have an obligation if they know that there's something going on. They have an obligation to let the court know, if there's a change of address. Lawyers certainly change their address, but in this case, in our technical record in front of the appellate court, in the Rule 13D, Tennessee, or the Rule of Appellate Court Procedure 13D says findings of fact are reviewed de novo on the record. Well, in this particular instance, there's no record. There's nothing in the record to show that anything was sent. The witness and exhibit list didn't even have a trial date listed in it, but that's the only thing that shows up in the technical record. In this particular instance, the trial court's order is based on a finding of fact in the trial court's decision that the defendant was forwarded notice to the South Seminole address. Well, there's nothing in the record to prove that. And that this court reviews that de novo, not as, that sacrosanct that the judge said it, so it had to be true. That finding is erroneous because there's nothing that indicates that notice was ever sent. Any of that. There's not even an order in the technical record. There's not even an order setting the trial date. So we don't know what was sent.
According to your opposing counsel's brief, it says the court found that the order allowing defense counsel to withdraw was sent to the address at Seminole Drive. The order specified defendants would have 30 days to proceed and obtain new counsel. They never did that. That order was entered on the 17th. By order entered July 20th, the case was set for trial and mailed to the defendants at the Seminole Drive address.
And that's not in the record, Your Honor. That is what she states in her order, but that's not in the record.
So if I look at technical record volume 1 at 124, I won't find that.
That's what I've looked at this morning.
All right.
I think you find that she stated all of this, but I also argue, and my argument has also been consistently, that if it was mailed to that address, my client testified, and it's in the transcript, that they hadn't lived at that address for a long, long time. And so from 2018 after withdrawal until 2020 when this thing was set, they didn't receive any mail because they were no longer at that address. And And
But
this
is that the address that the court had as being the address of the party to whom notices were to be sent?
That was the address the court had when the original complaint was filed in
And that's
2012.
the only address that anyone had an obligation to send anything to, correct?
That's the only address that was in the record, in the court record. Yes, ma'am. My argument is, though, that at some point, there ought to be a requirement to, after so many years go by, to try to determine if we don't know because it's not in the record. Maybe Mr. Burt got all this mail back at his office, and that was never established in the record. What is established is there's not, in this technical record, there's not all of this information that he lists as part of the court record that was provided to this court. And, and it's my position that...
Counsel, excuse me for interrupting.
Yes,
did the trial court make any credibility determinations?
I think the trial court, my client is an immigrant, and I think the trial court said that they did not find her testimony, where she testified she never got anything. They didn't find that credible. I think that says that in the transcript. To me, that wasn't determinative as to the issue of whether they got notice or not. There was documentation provided which reflected what the correct address was, and her testimony was she hadn't lived at the other address for years. But
Let me go back to this issue of whether or not it was mailed, because I'm also reading the trial court's order after hearing the hearing, at the hearing, and the trial court made the finding that following this, by order entered July 20th, 2020, this case was set for trial, and the order setting the trial was mailed to defendants at South Seminole. So where did the trial court get that information?
I don't know, Your Honor.
Okay.
I don't know. It's not in the record.
So there's no order in there setting it for trial?
There's not an order in your technical record setting it for trial. There's a whole lot of other stuff that's not in there. So in short, like I said, this is one of those which effectively the standard is it's a default judgment, and default judgments are disfavored, and my client should be allowed to contest this case rightfully in a manner that's normally afforded. Thank you, Your Honor.
Burt?
May it please the court, I'm Ronnie Burt from the Chattanooga Bar. It's kind of difficult to answer a brief that cites no facts. If you look at Mr. Presley's statement of facts, he doesn't give any. He has 4 citations to the technical record, but he cites no facts from the hearing on the motion to set aside the motion for default. This case being a motion to set aside a default under 6002, the standard of review is an abuse of discretion. And for instance, that the judge applied the wrong law or something like that. Well, in this case, the law that the judge applied is the exact law that Mr. Presley says she should apply, which is to look at the 3 factors: willfulness, whether they've got a meritorious defense, and whether it prejudices the defendant. So there's no question the judge used the proper law. The brief submitted by the defendant or the appellant does not comply with the TRAP rules. 27A4 says the statement of the issues must be specific, and all that the only allegation of the issue cited by the defendant is that the court erred in denying the motion to set aside the default judgment. There's no specific reason given. We have cited on page 10 of our brief other cases where people have given general issues and not been specific. And for instance, we cited the State versus Dykes case where the issue was presented as the court erred in overruling the motion to dismiss without giving any specificity. The court said that's not good enough. You're not specific. You've waived it. We cited another case that said this error was alleged that the evidence was insufficient to sustain the verdict of the jury. The court again said that's so general, it's not specific. You do it generally like that, you've waived it. All of that is under Trap Rule 27A4. They've also violated Trap Rule 27A6, which requires the appellant to give a statement of the facts setting forth the facts relevant to the issues presented for review. Well, in his statement of the facts, he's given 4 citations to the technical record, but he's given no facts and no citation of facts from the transcript. 27A7A also says the contentions of the appellant with respect to the issues presented and the reasons therefore, including the reasons why the contentions require appellate relief with citations to the authorities and appropriate references to the record must be relied upon. Well, again, he gave no citation to any facts. The only thing that you're going to see in the record with citation or the facts or a review of the facts is what the judge found. We pointed out that when an appellate fails to point out specific testimony or events in the record, that they waive their appeal, and that's the case we cited as State v. Parker. State v. Killebrew again says that the appellant who fails to include references to the record results in a waiver of the issue. We have also, there's numerous citations from the Court of Appeals case of Little versus City of Chattanooga, which emphasizes in bold print that you have to have specific references to the record. Again, there are none. You have to give citations to the facts in the record to show what is error. There was none. And you have to specifically say what facts you're relying on and point out those facts in the record. Mr. Presley gets up here and he says, well, my client has no notice, but he doesn't cite any facts in the record showing she had no notice. So what are the facts that the record supports? And we have citations to the record in our brief. The lawyers for the defendant withdrew in September. The order went down in September 2018. The defendant that testified stated that she never talked to a lawyer since 2016. She then said that she moved from the South Seminole Road address in October of 2018, but the order allowing their withdrawal and requiring her to obtain new counsel, or saying if she does not obtain new counsel within 30 days because it's a corporation we're suing, they can't represent themselves, that the case will proceed whether the corporation gets new counsel or not. She did nothing. She was still at the South Seminole address when that order was sent, not only by her attorneys, but the clerk and master also sent copies of that order to her. Additionally, she filed with the state of Tennessee corporate forms, which showed that even after that address, she was still at the South Seminole address. Furthermore, she testified that she left a forwarding address and she received mail at her new address. From 2016 until 2021, she never checked to see what was going on in this case, and the judge cited the law that says that you have to keep the court apprised. She knew where the court was. She knew where the clerk and master was. She knew that I was the attorney. She admitted this in court, that she knew I was the attorney for the plaintiff, but she didn't give anybody notice that she was claiming that she was moving. She also admitted that prior to June 17, 2019, and this again is almost a year after this September 2018 order goes down, that she still listed the South Seminole address as the corporate address. I think those are some of the reasons that the court found that she had no credibility. The court considered the three factors that the appellant says that she should have found, and with regard to willfulness, that doesn't mean that I intentionally do something, but the court found that she had an affirmative duty to notify the court and cited numerous cases that she had an affirmative duty to notify the court of her address. She can't just sit back and wait and say, well, you know, I didn't know. So under that, the court found that it did meet the first factor of willfulness. The second factor is whether the defendant has a meritorious defense. They didn't even allege that they had a meritorious defense, much less prove one in court. The chancellor went through and found that she was not a credible witness, and that she knew that Mr. Jahen was claiming that he was injured while working for the company. She admitted that Mr. Jahen was an employee of the company. She stated that when Mr. Jahen was injured, he was driving one of the company's trucks up in New Jersey. She stated that she knew all of these things and knew that he was pursuing a workers' compensation claim, but yet she just totally ignored things. She established no meritorious defense, and as I said, didn't even allege one in her motion. And the court, with regard to meritorious defense, found that that the company defendant did not have a meritorious defense. With regard to the third factor, which is there a prejudice to the plaintiff, the court found that it was the ultimate prejudice to the plaintiff, because after the judgment, but before this motion to set aside was filed, the plaintiff died. So if the case were to go forward now, there's no way that the plaintiff could prove a case, so that's the ultimate prejudice. The interesting case that we've cited on page, I think, 15 and especially 16 of our brief is the Berge versus Warlick case. And in that case, the court indicates that if you prove that it wasn't willful, then you go down and was there a meritorious defense? If you prove you had a meritorious defense, then you go down to the third factor, to see if there's prejudice to the defendant. The Berge case said, and I'm quoting from the case, says a reviewing court must first determine whether the conduct precipitating the default was willful. If the court finds that the defaulting party has acted willfully, the judgment cannot be set aside on excusable neglect grounds, and the court need not consider other factors. If the conduct was not willful, however, then the court must consider whether the defaulting party has a meritorious defense and whether the non-defaulting party would be prejudiced by the granting of relief. The court may also consider any other factors. And we have cited some other language also from the Berge Court. So the court finds, number one, that it was willful, so the court really didn't have to go further. But the court went on to find that there was no meritorious defense alleged and that there was no meritorious defense proven. And again, she was not found to be a credible witness. And the court then said, even if they had those, certainly there is the ultimate prejudice in this case. We asked the court to affirm the court's findings, both for the reasons that the appellant has not complied with the Tennessee Rules of Appellate Procedure, but when Mr. Presley gets up here and says, well, my client didn't have notice, he hasn't pointed to any evidence in the transcript to say that the client didn't have notice. All he does is makes a few vague recollections, and a few vague allegations of fact. We think the judge spent a lot of time researching not only the facts of this case, but did a good job researching the law. And for both the factor that the defendant did not prove any of the three factors, that this case should be affirmed. Thank you, Your Honor.
Yes, sir. Your rebuttal.
There was an answer filed in this case, and it is part of the technical record. And the answer clearly raises all the defenses that this individual was not an employee. Those defenses were never proven because my client was not at the trial that was conducted in this matter.
Did she admit, though, at the hearing that he was an employee?
She did not admit at the hearing that he was an employee. She's consistently stated in fact, she has clearly and consistently stated that he was not an employee. The employee argument was merely what happened at the solo trial that occurred when Mr. Burke put on proof that was not rebutted by anybody because we weren't there.
If we agree with you and we reverse the trial court's decision and this case goes back for a trial on the merits, how can the plaintiff pursue his case when he is now deceased?
Well, in fact, the estate has already interceded as the plaintiff in this particular matter, and there would have to be proof, as in any case. In these workers' comp cases, almost all the plaintiffs say the same thing. There is going to be some proof he would have out there. His statement that my case is dead, that's not what the law is. So the ultimate prejudice, and that prejudice didn't exist at the time I filed the motion. That's a post-motion action that occurred not when I filed the motion. I'm certain on appeal, can almost guarantee, there have been many cases when people have died before their appeal was granted or denied. And that certainly wouldn't be something that I think or I've seen in the decisions of the appellate court that come into play. So there were meritorious defenses, and I wanted to point that out quickly that's not accurate. The other part is I've said it in my facts. I don't know how to specifically say it other than the same thing I'm saying here today. She didn't get notice. She did not have notice. The technical record doesn't reflect that she got the notice. The record doesn't reflect it. I don't know why. The record is the record. I can't make the record up, but it reflects that she didn't get notice. And some of the most important notice that should be there is she knew when this trial was going to happen, and she didn't. And so from that perspective, she never participated in any trial or defense of this particular action. And we're asking the court to remand. What happens on remand is going to have to be determined by what happens on remand. Thank you, Your Honors.
Thank you. What thank the lawyers for your presentation. Your case has now been submitted to this court. You should receive our opinion and decision within a reasonable period of time. Thank you very much, and you may be excused.